Labor law is often the most overlooked yet impactful area in mergers and acquisitions. In Vietnam, employment law is strictly regulated and highly protective of employees. A mistake in handling labor matters during or after an M&A transaction can result in lawsuits, fines, reputational damage, or even business disruption. In this video, we help foreign investors understand how employment law applies in M&A transactions in Vietnam and what legal steps are necessary to ensure a compliant and smooth transition. The first factor that determines how employment law applies is the deal structure. In a capital deal, where the buyer acquires shares in the target company, the legal entity remains unchanged. Employees continue their contracts with the same employer and no transfer takes place. In an asset deal, however, the buyer acquires selected assets and establishes a new legal entity. Employees are not automatically transferred. New employment contracts must be signed, and in many cases, employee consent is required. Understanding this distinction is critical to planning your HR transition strategy. If the buyer intends to terminate some employees post-merger, for example, to eliminate duplicate roles or restructure the business, Vietnamese labor law imposes strict conditions. Dismissal must follow legal grounds such as redundancy, changes in organizational structure, or performance issues. Termination without proper legal basis or procedure can lead to legal claims and compensation obligations. Employees are entitled to notice periods, severance payments, and in some cases, job placement support. Legal counsel should review all proposed terminations to ensure compliance. Vietnamese employers are required to register all eligible employees for social insurance, health insurance, and unemployment insurance. Contributions must be paid monthly, and failure to do so is a serious legal violation. In M&A transactions, buyers must check whether the target company has fulfilled these obligations. Unpaid social insurance contributions, underreported salaries, or fake contracts are common issues. These liabilities do not disappear after closing and may become the buyer's responsibility, especially in capital deals. Every company with more than 10 employees in Vietnam must have registered internal labor rules. These rules govern working hours, discipline, leave, and employee behavior. In some companies, collective labor agreements may also apply. During due diligence, buyers must verify whether these documents exist, are properly registered with the Department of Labor, and are consistent with actual HR practices. Discrepancies between policy and practice can expose the company to compliance risks and legal disputes. Senior executives and key personnel may have special employment contracts with extended notice periods, high severance terms, or golden parachutes triggered by changes in control. If not reviewed in advance, these clauses can lead to unexpected payouts or retention issues post-closing. Buyers should request full disclosure of all management contracts, review change of control provisions, and negotiate adjustments or waivers as needed to avoid future financial and operational surprises. During legal due diligence, it is essential to investigate whether the target company is involved in labor disputes, arbitration cases, or employee complaints. As Vietnam does not maintain a centralized public database for labor litigation, this review often depends on disclosures by the company and verification through internal records. Even minor disputes can escalate if unresolved at the time of acquisition. Buyers should also check whether previous terminations were handled lawfully to assess potential future claims. In practice, the way a merger or acquisition is communicated to employees can significantly affect morale, retention, and legal risk. Vietnamese labor law requires that changes affecting employees, such as employer transfers in an asset deal, be clearly communicated and consented to. Employees who do not agree to transfer may have the right to terminate their contracts and claim severance. Transparent communication, proper documentation, and early engagement with employees help maintain stability and reduce resistance. In many Vietnamese companies, trade unions play an active role in protecting employee rights. They must be consulted on matters such as mass layoffs, restructuring, or changes in working conditions. Ignoring trade union procedures can lead to protests, investigations, or public backlash. After closing, the buyer should monitor ongoing HR compliance, implement legal employment policies, and ensure that contracts, benefits, and workplace conditions align with Vietnamese law. At LTS Law, we advise clients on all employment law aspects of M&A transactions in Vietnam. We review labor contracts, assess compliance, recommend restructuring strategies, and assist with employee communication plans. Whether you are entering a capital deal or asset deal, our team helps you anticipate labor law challenges and implement practical, legal solutions. We aim to protect your business while preserving workforce integrity. Employment law can be a silent risk in M&A if not handled properly. Let LTS Law support your HR legal due diligence, workforce planning, and post-merger compliance in Vietnam. Visit lts.com.vn or contact our team to schedule a consultation. A successful deal starts with respecting and managing your people the legal way.